You're now live.
Okay, yeah, I've moved the thing in front of me. Okay, I'm going to call the meeting to order. This is Senate Finance on January 25th. And we're going to start with S53, who despite the title is really corporate income tax. And what I got an email from Graham saying he is still working with Tom Cavett to come up with an estimate of any revenue loss. I don't know if Commissioner Bolio has some revenue numbers for us at this point. But I think as it's approaching the 1st of February, I am trying to figure out if this bill is going to move forward. If not, then we can drop it. Or what kind of information or what do we need to know before we feel comfortable working on it? And Commissioner, I'll look at you and see if I can do a layman's summary. But basically now when we calculate a corporate income tax, we look at sales, property, and personnel, right? Or wages. This would say we would look at sales only, which would benefit Vermont-based businesses. And these are C corporations only. So somebody that might make cheese or ice cream in Vermont, but not do the bulk of their sales in Vermont. To offset that, we now have 2 tiers of corporate minimum tax. We have expanded that to, I believe, 4 tiers and raised the minimum tax. Is that essentially what this bill is doing?
You've stolen a lot of my thunder, Madam Chair. There's a little more to it,
Okay.
but yes, that's a fine summary to start. That's okay. Repetition is good in the world of corporate income tax. That's what I've learned.
Corporate, I think because we haven't done corporate taxes in most of our lifetime in the Senate. I mean, it's been years, and it's easy to get bogged down because they can get very complicated. But I don't think what this bill is doing is that complicated. And I just am trying to see if it is possible to move it along or what any roadblocks might be. So help us.
Happy to do that, Madam Chair. So I have with me today, Craig Bolio, Tax Commissioner. I have with me today my executive assistant, Mariko, and some of you folks may have interacted with her in scheduling meetings or testimony. Some folks may have remembered my previous assistant, Kate. She is now our Assistant Director of Property Valuation and Review. And Mariko has been on for a few months now, and really excited to have her with me. She's going to share screen on a presentation for me.
Okay.
And this should be on your website.
Sure it is.
And Mariko, do you want to introduce yourself and start sharing whenever you are all set?
Yes, my name is Mariko Evans. I'm executive assistant to Craig, Commissioner Bolio, and I'm just really happy to be here. And right now I'm trying to figure out how to share my screen. So
Okay.
bear with me. There we go.
There you go. Okay. Committee, I'm going to have to make all of you go away so I can see this. So if you have questions, holler. Okay.
Good to go, Madam Chair?
Good to go.
All right. Thank you so much. Maud, please, let's move to the next slide. And so I'm going to talk today about the 4 main elements of corporate reform in S53, and there are some other elements that we'll talk about in a minute. But Section 5 has the transition to what's known as single sales factor. Section 6 has a transition from Joyce to Finnegan. Section 3 repeals the 80/20 exemption, existing exemption for 80/20 companies. And Section 5 also repeals the throwback rule. We're going to go into details of each of these things, but I just want to characterize sort of the overall picture of what I'm talking about. Next slide, please, Maud. So as I just said, there are some other elements in S53, and I'm not going to spend a lot of time talking about those today. The increase in the minimum corporate income tax is not something that the governor supported last year. It's in Section 4. I also think that the mechanism for it right now is outdated because one of the reasons it was added in House Ways and Means was as a pay for. And while I don't have exact numbers today, the fiscal note on this bill is going to change. I think it's going to change significantly. And so the amount of money that the change in minimum tax was raising, I don't think is doing the job that the House had believed it was. The cloud tax is something that the governor has been very clear on that he doesn't support. I'm also not sure it's really germane as a pay for because it's going into the ed fund and corporate income tax goes into the general fund. And then there are mutual fund fee increases in this bill. It's something that I'm not an expert to speak about. Commissioner Pichak would. Frankly, this is not a provision that I've circled back to the administration about this session,
Okay.
but not going to be my focus today. In addition,
I've made a note to have DFR in. So,
in addition, the original purpose of this bill, as it had come out of this committee in the Senate, was exempting menstrual products from sales tax, and that has become law in Act 73, which was last year's miscellaneous tax bill. And then also the House added an exemption for the first $10,000 in military retirement pay into this bill. Certainly the governor supports that, although he is hoping that the legislature will go and exempt the entirety of military retirement pay. But again, won't be my focus for today's discussion. I'm really going to hone in on the corporate income tax provisions. Next slide, please, Maud. Thank you. So let's talk a little about like who's impacted by this reform, right? So the first element is it's C corporations. So it's not pass-through entities, it's not S corps, it's not partnerships. And I want to also just stress the fact that it's big C corps. It's businesses that do it's businesses that operate in multiple states or multiple countries. These four main elements of corporate reform that we're talking about today, generally speaking, do not impact small businesses in Vermont. Next slide, please, Maud. And maybe the meat and potatoes of what I want to talk about today, but like why should we care about this? Why should we think about doing this? And I think it's really important from a number of different perspectives. The first is a policy consideration. I really believe that it is a better structure for corporate income tax to reflect where the companies avail themselves of the market, right? So to the degree that we believe a corporation's income is derived from where they're making sales and where they're availing themselves to the market, this better aligns the structure of our corporate income tax to reflect that. And I think that that's one of the main reasons that a lot of other states have pursued this, particularly when we're seeing the nature of the economy change, right? Where local businesses are maybe less of a share of the market and larger multi-state, multinational businesses become a larger share of the market. It also removes a possible barrier for expansion or relocation of property and workforce into Vermont. Right now, every additional job that you bring into Vermont or every additional building that you build in Vermont increases your corporate income tax, all else held equal. This reform essentially makes the corporate income tax agnostic to those things. Oop, go back up, Mud. This makes the corporate income tax agnostic to those things, right? Moving more payroll or property into Vermont will have no impact on your corporate income taxes. And one element of this that I think a lot of states have recognized as well, and I think has been in Graham's and Abby's prior presentations on this, it's difficult for me to say hard and fast rules about who wins and loses under this proposal, but generally speaking, these reforms will decrease the corporate income taxes for multi-state C corps that have a large presence in Vermont, being lots of jobs or lots of buildings, where they're outsourcing sales, and increase taxes on companies that don't have a large footprint with people or property in the state and have a lot of sales coming into the state. So generally speaking, decreases taxes on in-state companies, increases taxes on out-of-state companies. Again, focused in that area of big multi-state C corps. And really one of the last things that I would highlight on the why is that it will help remove sort of the double hit that Vermont companies are feeling today, based on the fact that a bunch of other states, including all of our neighbors, are under the single sales factor policy. And that means that Vermont companies who are doing business in the state and other states are both getting this out-of-state hit that I just talked about when they sell into other states, but they're also getting hit from the fact that Vermont is still taxing them on property and payroll. So let's move to the next slide, Maud, and we'll talk a little about what other states are doing. So all New England states and New York use single sales factor. And in fact, it's kind of interesting when you look into this, talking about sort of the protectionist nature of this. Massachusetts has enacted single sales factor, but they've done it for specific industries that they want to favor. So manufacturing, defense contractors, and financial services are all under single sales factor in Massachusetts, and other industries are under the 3-factor apportionment. And as you can see in the final few bullets, it's really sort of the trend. It's really the modern way of administering corporate income tax. In the past 10 years, 18 states have moved away from a 3-factor apportionment to single sales factor. My team is not aware of any that have gone the other direction. In addition to that, when you look at Joyce to Finnegan, we are a Joyce state now, and this proposal moves us to Finnegan. There are 18 Finnegan states, 13 Joyce states. So again, feels like maybe it's an even split. But if you look at the last 10 years, 7 have transitioned from Joyce to Finnegan. And just like with single sales factor, my team is not aware of any states that have gone the opposite direction. Next slide, please, Maud. So before we jump into each of the individual elements that I'm going to talk about today, I just want to hit 2 key concepts. The first is apportionment, right? And so that's the methodology by which states determine how much of a company's income should be reported to that state for income tax when a company operates in more than one state. And that's what most of these reforms change. It changes the methodology for apportionment for companies operating in more than one state. And the other element that's impacted by these reforms is unitary reporting. This is current law in Vermont since 2006. I've got it there. I think it started maybe tax year 2007 though, which requires related businesses with common ownership to file as a unitary group. And really the overarching reason that states have unitary filing is to prohibit transfer pricing shenanigans that lead to tax sheltering. So basically the income of the group is apportioned in one tax return. And this has been a win for Vermont. We're happy with that. So it doesn't change the nature of unitary reporting, but it does change the composition of the group slightly with these proposals. Yep, thanks, Maud. So single sales factor is the big one in the package of 4, right? Vermont currently uses 3 factors to determine the share of total income apportioned to Vermont. How much are you selling into Vermont? How much of your payroll do you have in Vermont? How much of your property do you have in Vermont? We actually double weight sales, so we count it twice in the formula. So a lot of states do that when they have the 3-factor. And frankly, that's sort of an acknowledgement that maybe sales are the best reflection of a company's income. Changing to the single sales factor, as you highlighted at the start, Madam Chair, means that the apportionment factor would only be the sales factor. So again, if we're highlighting who wins and who loses, the winners are companies that have more payroll and property in the state than sales, right? You could imagine a company that has, an easy example would be they have all of their payroll and property here. They have all their jobs, all of their production buildings, but they sell all across the country, right? They would win under this proposal because their apportionment factor would now become less than 100% from their sales factor. And who loses? the companies who are selling into Vermont that have little or lower payroll or property than they do sales, right? So again, you can think about financial service companies, internet retailers, folks that don't necessarily have a big payroll and property presence in Vermont, but have a lot of sales into Vermont. They are likely to see taxes go up under this proposal. And remember, if it's a full Vermont company, all sales, all payroll, all property, there's no impact from this, right? They're already reporting all of their income to Vermont, and they would continue to do that. So the small mom and pop businesses, I don't think many of them operate as C Corps anymore, but to the degree that they do, the smaller Vermont-only companies are not going to be impacted by this one way or the other. Next slide, please, Mont. Thank you. Joyce to Finnegan. So not based on literary references, but the names of two court cases that led to two different methodologies for determining sales apportionment factors for unitary groups. And so there's a lot of legalese on this, and then a sort of a bottom line that I always focus on. Under Joyce, the taxing jurisdiction for each company is evaluated individually within the group. And under Finnegan, the group is evaluated as a whole. Both of these methodologies still require unitary filing. And really why this matters in the grand scheme of things is Public Law 86-272, which is a federal law from I think the late 50s maybe, that was originally designed to protect catalog sales, that essentially says a state cannot impose its income tax on a company that is only soliciting sales of tangible personal property into that state. And so under the Joyce system, which we have now, each company is evaluated individually for whether or not they can claim the protections of Public Law 86-272. And remember, the protections of 86-272 essentially mean that a company could be selling a whole bunch of stuff into Vermont and not pay any income tax on it, right? But under Finnegan, if one member of the group cannot claim the protections of 86-272, it means the entire group cannot claim those protections. And this is important, right? Because companies may structure themselves in a way such that some of the subsidiaries do not trigger, how do I want to articulate this? They might set up some of the subsidiaries to be able to be under the protections of 86-272, where other subsidiaries exceed the protections of 86-272. And under Joyce, that would be completely acceptable. And those subsidiaries that are selling a bunch into Vermont would not pay any income tax. Under Finnegan, that kind of gamesmanship is not feasible unless the entirety of the group can claim 86-272, in which case we're no worse off under Finnegan than we were under Joyce, but we have, I don't want to call it a loophole, but we have closed an area of tax planning. And the reason that this is a natural pairing with single sales factor, right, is if you're going to rely on the sales to be the sole apportionment factor, you want to make sure that that companies have to report their sales, and that you're not going to have companies being able to structure themselves to avoid that. So it's really a natural pairing, and I think that's why you see the trend both for single sales factor and moving from Joyce to Finnegan. Next slide, please, Maud. Throwback rule. Admittedly, this is a very small piece of this reform, very low fiscal impact, but it is something that has a natural tension with single sales factor. So the throwback rule is for tangible personal property, and essentially companies have to report sales that they made to the federal government or states where they're not taxable or states where they claim the protections of Public Law 86-272 back to Vermont if they're a Vermont company. So that's the throwback, so to speak, to the home state. And, you know, if the committee agrees that where you're availing yourself of the market is a better reflection of how you're generating your income, then there's a natural tension between that policy position and throwback, right? Because now you're having companies sort of arbitrarily throw back sales to Vermont, even though they were not Vermont sales. So from a policy standpoint, we support repealing the throwback rule. I've got to say, you know, for complicated reasons, if we pair this with a change from Joyce to Finnegan, the impact is really, really small. And the high level reason for that is that as each state is determining who must throw back sales, they treat all other states how they treat themselves. So if Vermont is a Finnegan state, it's going to look at all other states as a Finnegan state, whether or not that state is actually a Finnegan state, which will mean, based on what we just talked about with Joyce to Finnegan, there are very few companies that can claim they don't have nexus or can claim the protections of 86-272 in a way that would be acceptable under Finnegan. So I think you're going to see far fewer sales thrown back anyway, which again means this probably is not worth the squeeze to continue to administer. Next slide, please, Maud. And the last piece of the 4 reforms, 80-20 companies. So an 80-20 company is a US company. It's not a company that's incorporated outside of the US. It's a US company that has more than 80% of its property and payroll overseas. You know, and I don't know the full history on this, but my understanding is that, you know, the original vision for these kind of companies were legitimate overseas subsidiaries of US companies, right? So think of like a food or drink distributor that, you know, was founded in the US and now wants to expand into the, you know, the market in Ireland, creates an Irish subsidiary or a US subsidiary that operates mostly in Ireland, right? But that's not necessarily what we see anymore. Now there are ways that this could be seen as a loophole. Companies may have one employee for the entire company and then station that employee in Europe, and you could park, you know, the entirety of a company's intellectual property revenue into that company and then carve it out of state taxation. And there are cases where this has happened with big companies. And I'd be happy to have my legal counsel speak more to that if necessary. But because of this sort of transition in the original vision and how they're used in the modern economy, the United States actually repealed its recognition of 80-20 companies over a decade ago. And now, out of all of the states that have unitary reporting, Vermont is in a slice of only 1/3 that actually still recognize this exclusion. I do want to highlight that repealing this exclusion is not the same as moving to worldwide combined reporting, which is a much bigger unitary discussion and is, you know, fraught with legal challenges, constitutional challenges. This is not that. This is just eliminating the protection that many other states have eliminated to try to avoid having tax abuse, I suppose. And I think that that's the end of my slides, but I said a lot, and I'm happy to pause there. I'm happy to take questions.
Okay, I think if we can take the slides down, we can all see each other. Committee, questions, thoughts? Okay, we've got Senator Pearson and then Senator Hardy.
Well, Madam Chair, you asked what we would need. You know, I'm skeptical of this, and I certainly can't imagine voting for it without us having an updated estimate from JFO.
Oh, yeah.
But my question is for the commissioner or Abby, our counsel. I believe that corporations can still deduct state taxes from their federal tax like we used to be able to. And I want to verify that because it seems that the touted benefits of these proposals for corporations end up being fairly limited if that's indeed the case. So I wonder if you can just help me think that through.
Yeah, they can deduct state taxes paid. Help me wrap my head around the second part of your question of how the reform would provide a benefit based on that.
So we're saying that this is of a benefit. I mean, to me, it should be. I'm not really interested in giving large corporations a tax benefit at this moment in time. But to the extent that you've said this is good for businesses, but in fact, if we make changes that save them money, they're just getting a different ability to, they get to deduct less Vermont tax from their federal corporate tax. That's, I'm not seeing a big benefit. They're going to pay, presumably that just means they send more money. If we're saving the money from this change, which you're advocating, then they just spend more money at the federal level, right? I mean, their overall, that's what I'm trying to understand, because the implications, I mean, I suppose that assumes they have a federal liability, but since they write it off, I'm trying to understand why it would really make a big difference to them.
Yeah, well, actually, I'm really glad you asked that, Senator, because I think it'll help me. I'm not sure I did a great job framing if the takeaway was that, this is a big tax cut for businesses. So first of all, let me address your question directly. I mean, in that case where they're deducting at the federal level, that's not a dollar for dollar trade, right? Because they're still only deducting and then hitting their marginal tax rate. But I actually I don't necessarily want to focus on this being seen as like a tax break. Like, this is a modernization, right? Even within single sales factor itself, there's going to be winners and losers, right? And your winners are going to be those Vermont companies who have payroll and property here and are selling out of the state. And those are the people are going to also see significant tax increases if they are selling a lot into this state and don't have jobs and buildings here, right? So this is not about like offering a break to all big businesses or offering a tax cut. Like, this is really a modernization and restructuring that I think is good for Vermont, and I think it's good for Vermont-based businesses. But not every element in here reduces revenue, right? Joyce to Finnegan will increase revenue by increasing the corporate income tax base and preventing some companies from claiming the protections of 86-272. And as will the repeal of the 80-20, right? The 80-20 rule will increase corporate income tax revenue. So I'm really looking at this as a modernization and as a restructuring that will help position Vermont-based companies to compete with companies in other states. But it's not this proposal, is not about a giveaway to big business. It's really a comprehensive package that has some ups, some downs. There are winners, there are losers. But I think in the long run, the policy perspective is that it makes it better reflect how a company is generating its income, and therefore making sure that companies are paying state tax to the states where they are generating their income from. And it does have additional benefits for Vermont-based companies who are at a distinct disadvantage right now because all of our neighbors have enacted these reforms.
Well, as the bill was presented to us, it was sort of revenue neutral after adding the cloud tax, and which I join you in opposing. So that's where we need to understand. I mean, we need to understand the actual fiscal impact in addition to the policies, I think. But thank you.
Yeah, I'm totally with you there, Senator. I didn't mean to imply otherwise. I do not have the revenue numbers today, and I don't want to speak on behalf of JFO. I mean, what JFO and my team have been talking about is that last year, like the single sales factor number, I think was like a $20 million down. It's going to be a lot less than that. So I'm not saying that these four proposals will become revenue neutral. If they do, I think they're a no-brainer. If they don't, I think there's further conversation to have, but they will be significantly closer to revenue neutral than they were last year, right? And then I think at that point, if we need revenue to make it revenue neutral, there are things we can talk about, right? The governor proposed one in the budget of sports betting, right, to increase some revenue. So there's opportunities there. I don't think that I'm ready to have that conversation today. I'm also waiting for JFO's updated numbers, but totally with you on that, Senator.
And we will get those numbers. And then I know you didn't talk about it, but I'm assuming that there's some revenue involved in the minimum corporate tax, which we will look at. Duly noted that the governor opposes it, but we will look at it and look at the revenue impact from that one as well. Okay, Senator Hardy.
Thank you, Madam Chair. Commissioner, thanks for this presentation. Every time I hear it, I'm like, oh yeah, I do remember this. It feels like it's always like this time period and my brain has to adjust to it. But two questions. You on the 80/20 company, you have I'm looking at your presentation over here and it says that because of this potential for abuse, the United States repealed their recognition of 80/20 companies in 2010. How, if the feds repealed their recognition of them, how are states still allowed to be recognizing them?
I might ask Abby for some help here. She knows part of this history off the top of her head, but essentially my understanding is that it was no longer carved out as an exception from the federal consolidated group, but states could. The federal government didn't make it illegal for states to recognize the exemption. They just repealed it for their own treatment.
Okay.
That makes sense.
Okay, so it's
Yeah,
not that their treatment overrode our treatment in some way. Is that right, Abby?
Yes. So for the record, Abby Shepherd, Office of Legislative Counsel, that's right. So the 80/20 rule and the worldwide versus the water's edge, which I don't think we've gone into great detail, but Vermont is a water's edge state. And as Commissioner Bolio pointed out, this wouldn't move Vermont to the other form where you pull in even foreign corporations. I think it was in the 50s. And I know that the MTC Bruce Fort presentation you had went into some detail on all of the history of this, but it was more of a sort of a federal working group that came up with different structures, more sort of uniform laws. It was never a constitutional requirement or anything in federal statute that then flowed through to Vermont. Each state had its own decision about which corporations to include and which to exclude.
Okay, so the 2010 federal decision didn't have a bearing on Vermont then. Okay,
That's right.
And thank you, Abby and Commissioner. The other question I have is back on the single sales factor slide. Your final point there is full Vermont company, no impact. How is that possible? So if they have sales, property and people in Vermont, and we stop taxing the property and the people part of the company and just tax the sales, wouldn't that be a decrease for them?
I'm actually really glad you asked that question. So it's because those factors only impact the apportionment factor, not the taxable income itself.
We don't.
Right. So imagine a company that makes $100, but they have half of their sales, half of their people, and half of their property in Vermont and half elsewhere. Then their taxable income is still $100, but their post-apportionment income is 50. So in this case, what I'm saying, full Vermont company, all sales, all property, all people are in Vermont. Their apportionment factor before and after this reform is still 100%. So their taxable income
I
stays.
see. Okay, that makes sense. Yes, thank you.
Sure.
Final question, and maybe this is for my colleague, Senator Brock, but was this proposal recommended by any of the number of lovely tax commissions?
No.
I thought it was, but I can't remember exactly. I think
The
this
blue
was
ribbon
mentioned
or
in
the red
tax structure.
ribbon or the you don't think so? Okay, I was just wondering if this was part of any of their proposals, but it sounds like no. Okay, that's all I've got for now. I do obviously want to see the JFO revenue stuff.
We'll get that as soon as we get that. Committee, anything else? Questions? Totally puzzled?
You're gonna have to move closer to your mic, Madam Chair.
That's strange because I've been further back. Maybe it's the angle. Any questions, committee? Any information you need to make a decision? Thoughts? Yes.
Madam Chair, I to that question, I've been trying to reach out to people like working assets and folks that try to think about these policies and understand. And generally the response I get is, yeah, we're starting to look at it. So they don't need to dictate our schedule, but just an FYI that to the extent some external minds greater than my own that I'm trying to hear from, there has not been much analysis ready to go, and I think that's underway, and I'll try to find out the timeline if that
Okay.
helps.
Or we've been trying to think of who we could have in to represent affected businesses. We could reach out to some of the Vermont-based businesses. So any ideas of who you'd like to hear from would also be helpful. And working assets, do they actually work with things as big as C Corps?
Well, no, they're a policy sort of analyst shop, so
okay.
they don't, they don't represent anybody in that sense. other
You
Okay.
than-
mean public assets?
No.
Oh, I'm sorry. Yeah.
Oh,
Yep.
public assets. Okay, yeah, I didn't see them. I actually
Working
talked-
assets is a phone. Sorry.
Right, exactly. Public,
That was a
you
long
need to-
time ago.
yeah,
Okay, now I'm back at it. All right. Yes. I actually talked with them the other night and nobody said anything, so we can ask them to come in and think with us. Senator McDonald, are you raising your hand?
Nope.
Nope. Okay, that was easy. Senator Bray, you look puzzled. Anything that would make you less puzzled?
Well, I'm not feeling puzzled, so I'm gonna have to figure that one out. Just sitting
Okay.
attentively listening.
All right. Anyone else? Anything you'd like to hear? Let me know. We are ahead of schedule, but I'm going to go on to Abby because we actually don't have a break scheduled today. And I think the chair's committee may be canceled. That was the last email, and I haven't gotten to look at my emails.
It has been canceled, Madam Chair.
It has been canceled. I saw I got a probably so. But David Hall has a hard stop at 4:30. So think about it and we can perhaps come back, to this if you have any thoughts. So Abby, why don't you walk us through this and maybe going through it section by section, we can kind of hone in on where the questions are. I have a note. We will ask DFR to come in and talk about the mutual fund fee and why that's there. And I'll talk to JFO and see if anyone there has done any work on the minimum corporate tax and what other states are doing in that area. So, Abby, floor is yours.
Thank you, Madam Chair. I have a few documents under my name on the website. I have an updated section by section, which we've looked at briefly. The last few times that I've been in on S53, we've sort of split out the different sections. This has everything in it as proposed in the House's amendment. So if you'd like, I can take you through that. You're aware of all of it at this point. I did want to make one clarifying point about the title. A title of a bill is what it is on introduction. That can be amended, but it doesn't take effect until passage. So unfortunately, it will technically still be.
Can we just put S53 on the agenda? I have never seen this. I mean, this is strange things happen at the end of the year, but usually it's on something like miscellaneous tax. This one is just the title and the actual subject right now couldn't be farther afield. So, all right.
In the House proposal of amendment, they also changed the title, but it would also, depending on what the Senate wants to do, it might not be applicable either. So that's one of the decisions that you can make in your report if you like.
Okay, so let's walk us through this. And is this okay? Let's do the side by side, and then this is like miscellaneous tax. We will go through what we finally decide. All right.
Okay, excellent. I'm trying out using my laptop instead of my iPad, so I hope this works better for the committee with screen sharing.
I can
everyone
see it. It looks very, yeah, it's good and
Okay.
clear.
I've graduated to using my laptop instead of my iPad. So this is now under today's date. This isn't vastly different from what you've seen in other iterations, but I will just take you through each section. So this is the underlying bill as was amended by the House. That kept in the first two sections. As the commissioner pointed out, there's the sales tax exemption for feminine hygiene products, no longer accurate language, given that that passed and is now law. That was enacted in the miscellaneous tax bill last year. One question or point that the committee has considered is changing some of that language to make it more respectful, using menstrual products instead. So if the committee did want to include that, this could be a vehicle for making that change.
Okay. I think we probably do want to do it, even if it's in this bill. All right.
Section 3 amends corporate income tax definitions. So this is the change to the 80-20 rule that we were just discussing. It deletes references to overseas business organizations and then deletes that definition altogether. The 80-20 rule is actually imposed under law. There is this definition, but the explanation and the clear imposition of that rule is through regulation. So once this went into effect, if it were enacted, it would require the department to change its regulations. The regulations would no longer be in effect.
Okay. Committee. Anyone have concerns about this section? Is this something we can put a check mark next to? I'm not hearing no.
Madam Chair, I'm
Yes.
embarrassed because I know the commissioner just went over it, but I don't understand it.
So there's the current, so let's take a step further back. As I was mentioning, there was this, I think, 1950s or 1960s working group federally that was trying to come up with different structures for getting at the income of both foreign corporations and US incorporated corporations. Again, we're just talking C Corps that operate abroad outside of the US. And the way the pie was sliced was to say those corporations that have more than 80% of their property and payroll outside of the US will be excluded from the apportionment factor. So their income won't be included. Vermont has this, as the commissioner mentioned, there are about a third of the states use this. Changing this, again, would not be bringing in foreign incorporated C Corps income. It would only be allowing US corporations that are operating abroad. It would require them to report their income.
But it only really makes sense if we're also doing the Joyce to Finnegan change, correct?
It goes hand in hand. I think you can look at them separately. One note, I know in some of the conversations that we've had, there isn't a lot of data because they aren't currently reporting. And I absolutely defer to JFO, and Graham will be able to explain this in more detail. It would probably be a positive, but this income is not currently being reported. So it's hard to know exactly what the universe is of corporations there.
Thank you.
Okay. So committee, if we do the Joyce versus Finnegan, this one, I'm not hearing any strong concerns on this one. So if you think of one, let me.
Remember, Madam Chair, that there is something in the draft tax study commission report that talks about Finnegan. And I may not be entirely correct on this, but it seemed to toss back the notion that we ought to look further at where we stand vis-a-vis Finnegan in particular, and seem to suggest that we should be thinking about Finnegan. I think we should just review that at least.
Okay.
What's in the tax study commission report before we make a decision on what we do here.
All right. We will pull that one out and see if we can find it. Because I remember phone polls and I remember looking at sales tax, but that one I didn't remember a section on. I thought all three took a section and that was it. So I'll
Yeah,
check. We'll check
that
out.
was in the draft report, I know, and I'm not sure whether it was in the final or not. I'm just
Okay,
not.
we'll find that out. Okay, we'll just drop me an email. All right, so this is the minimum corporate tax. And again, I'm going to ask Graham or whoever is in charge over at JFO to give us some numbers and some background on this and what other states are doing. But Abby, why don't you walk us through what is being proposed?
Sure. So the way I've set it up, I put what is the proposal, and then underneath are the current amounts, what's charged as a minimum corporate income tax. But I'm actually going to just focus on the structure. So you have brackets. The current structure is quite a bit lower than the proposed new amounts. $0 to $2 million of gross receipts in Vermont is only a $300 minimum tax. Whereas under this proposal, that's split out from 0 up to $1 million. There are two different new fees. It drops the lowest fee to $250, but then $100,000 to $1 million of Vermont gross receipts, it imposes a $500 minimum tax amount, and then $1 million to $5 million, it's a $2,000 minimum tax. So there's a significant change there in the amounts, really making it more tied to the amount of the Vermont gross receipts. And then as you see, there are two further brackets, rather than anything over $5 million in gross receipts being subject to a $750 tax. There are two new brackets, $5 million to $300 million is $6,000. And then over $300 million is a $100,000 minimum tax. It did not change. I did make one small note under their current law does have a $75 minimum for small farm corporations, which is defined under statute. That is not changed. So that's retained. I think you should probably hear from JFO about the fiscal amount there.
Yeah.
That was the
definitely do
main.
that. I assume the small farm corporations is that farms, some of them are C Corps. So we'll hear from them too and maybe run this by ag. All right. Well, there's no change. So we'll let that go.
That doesn't change their treatment.
Right.
So just-
Okay.
Madam Chair,
Questions? Yes. Senator Sirotkin?
correct. Just to be clear, so the minimum tax amount is based on gross receipts and has nothing to do with the income of the corporation?
So it doesn't follow the taxable income. It's Vermont net income is what's subject to the existing progressive rate structure. This minimum looks at gross receipts. So it's two different bases.
Okay, this is just for the minimum tax, not for corporate
Yes.
income tax.
That's right. It does not change the underlying rates. It's just for the minimum.
Okay, so you pay at least that much. If you owe more than $250, you pay the greater, right?
That's right.
But you pay at least that much if you have that much
Gross
gross
receipts.
receipts right now, right?
That's correct, Madam Chair.
Okay.
Okay.
Okay, any other questions? Committee, we'll have Graham in on this one. And we'll see where that goes. All right. Ready to move on to section 5.
Right. So section 5 is where the single sales factor change is made. So again, we're talking about the apportionment factors. It's not determining taxable income. It's determining how much of that income will be apportioned to Vermont when a corporation has income from different states or different jurisdictions. It also repeals the throwback rule, which occurs when there's income that is neither taxed and is not taxed in another state, either because it's a sale to the federal government, which is exempt, or because the corporation just is not taxable in that other state. Currently, the language in section 5833 does what's called throwbacks. It throws back that income to Vermont so that it's included as income apportioned to Vermont. This language, as proposed by the House, repeals the throwback rule. And so there would be no throwback rule for sales of tangible personal property. The language also includes a reporting requirement because it repeals the property and payroll factors for apportionment. It still would require C Corps to report that information, that data to the Commissioner of Taxes. I believe other states that have made the move to single sales recommended that reporting requirement so that the state could continue to measure the change in income that's being apportioned to the state. Shall I move on to the Joyce?
I think so. Any questions at this point? All right. I'm not hearing any, so let's move on.
So still within this universe of a unitary combined filing group, where you have multiple entities, can be any parent or subsidiary structure of a C corporation. There's the Finnegan rule and the Joyce rule, as the commissioner was presenting. They're not relating to any literary reference. It is some cases, I believe, from the 90s in California. They each took a separate approach to apportionment and determining state jurisdiction over income. Currently, Vermont has the Joyce rule, which looks at each individual corporation within a unitary combined filing group and looks at whether they have nexus with Vermont. Under the Finnegan method, if one of those corporations within a group has nexus with Vermont, all of the members of that group will have their income apportioned to Vermont. So it looks at a unitary group as one single taxpayer. Within this section, it also, there is a reference to the 80-20 rule, just to make it clear. It does require the income and the apportionment factors of all taxable corporations that are incorporated in the US to be included in that unitary group's return. There was also, sorry, I'm just trying to go slowly in case there are any questions.
Are there questions at this point?
I have a question.
Yeah, okay, Senator Hardy.
Abby, on section 5, I guess it is, you say requires taxable C corps to continue to report their property and payroll to the tax department, the commissioner.
That's right.
And maybe this is a question for the commissioner. So if they would continue to report it, even if it's not used in apportionment.
That's correct.
And therefore, in theory and hopefully in practice, we would be able to do some post analysis if we were to adopt this legislation, pass this legislation, to see what the revenue impact is, would have been, right? Is that okay?
That's exactly the intent.
Great. I like data. Thank you.
So do the other states that made this change. They believe that was a recommendation.
Okay.
So one other point in section 6 of the bill, in section 5862 of Title 32, it does specify that a state credit cannot be combined and with other state credits, and it's limited to the members that have the credits. So I'm just going to pull up the language to make this clear. If there's a member who is in another state who has a tax liability and a member in Vermont has a state credit, that other member could not avail themselves of that credit. So it only applies to the member of the group that's actually earned the credit.
Okay.
That was a recommendation from the Multi-State Tax Commission.
Okay.
The final two sections relating to corporate income tax have to do with the transition. So the first really lays out the Finnegan method, and it states how, also the effective dates are important to note here. In the bill language, this is all would have taken effect January 1st of this year. So if the committee did want to keep those dates and have corporate income tax reforms starting immediately, starting this taxable year, there would need to be some retroactive language. Otherwise, another option is for the committee to start this next taxable year. So I'm just going to explain based on the dates that are in here. So for taxable years beginning on and after January 1st of 2022, for purposes of determining whether sales are included in the numerator, included in the apportionment factors for Vermont, if any member of a unitary group's activities create nexus with Vermont, then the sales of tangible personal property into Vermont from any members of the unitary group are included in the Vermont apportionment factors. So it just lays out the test again and sets it out for the different taxable years. Then for the next taxable year, going from January 1st, 22 through January 2023, if any member of the group is taxable in another state, then the sales of their tangible personal property from Vermont into that state will be excluded. So that's allowing, because the throwback rule has been repealed. And then if no member of a unitary group is taxable in another state, sales of tangible personal property from Vermont into that state by all members of the unitary group are included in the Vermont sales factor. Again, if the committee wished to change any of the dates, that would need to be addressed in this section.
Right.
The last section requires both a report and rulemaking by the Department of Taxes to come back to the legislature, both to propose rules that explain and interpret and implement these new laws, and also provide any recommendations for further amendments.
Madam Chair, can I ask a couple questions?
Yep.
Okay, so on that last thing, they would have to come back to the full legislature with rules? Does it not go through the regular LCAR process, or?
Sorry, yes, it would. It would go through LCAR. It just
Okay.
requires the department to make rules, and then House Committee on Ways and Means, and then your committee, Senate Finance, would come back. The department will come back with any recommended legislative changes.
Okay. And then my other question is about in number 6. I was trying to wrap my head around this while you were talking about the dates, but in the state tax credits issue. So the for all the other things are combined, but state tax credits are not combined, meaning that if there are a bunch of subsidiaries, only the one that actually has a credit can use it. They can't all use the same credit. Is that the point of this?
Yes, that's my understanding from the MTC's recommendation.
Okay, because if without this, it would mean like one credit could be used 20 times or something, potentially.
It could be used by another member that has a liability.
Okay, so this is protecting the state from sort of overuse of tax credits. Is that?
I think that's a fair
That's my
characterization.
word. So, but yeah, okay. Thank you.
Madam
Okay.
Chair,
Commissioner Bolio, I have a note that you have your hand raised.
yeah, that's it.
Yeah, just a real quick comment. I appreciate Abby flagging the effective dates. If the committee's interested in moving forward on this, the department does request pushing out the effective dates by 1 year, which would be the
Okay.
equivalent of what they were last session. It's a lot of work to like rewrite our apportionment regulation and all of that kind of stuff. And we certainly wouldn't want to have this change retroactive to tax year 22. Thank you.
Okay, thank you. Senator Bray, did I hear your voice?
You did, and I was just going to say, Commissioner Bolio's hand is up, but
Oh, okay,
that's all.
all right. Committee, I guess, Abby, you can take that down. Any questions, yes, this clearer after going through that or less clear? It's less clear. All right, let me get my agenda back up here. So I think what we'll do is we will send something out to public assets to ask them if they would like to say anything. And we will wait for Graham to finish both the revenue, but see if either Graham or somebody at Joint Fiscal can help us walk through the minimum taxes and what other states are doing there. And maybe we will ask the reporter or the chair of Ways and Means to talk to us about their thinking with the minimum tax. So Senator Sirotkin.
Thank you, Madam Chair. This is probably somewhat of an unfair question, but given the complexity of these things, in terms you almost need to be a CPA, would it be possible, I don't want to put the commissioner on the spot, to help us understand what the counter arguments might be to these proposals?
Yeah, I'm not sure I'm prepared today to offer all of those, Senator. And one of the challenges, not to be too cheeky, is I think that the trend across states has shown that there are not many counter arguments, right? Like this is the trend across all of New England. Again, 18 states in the last 10 years that have moved to single sales factor, 0 that have gone the other way, 7 on Joyce to Finnegan, 0 that have gone the other way. I mean, there are, especially folks that I think the House had spoken with before that I'm sure would be happy to come in, and I'm happy to try to make some of those connections. Bruce Ford at the MTC was one of them who can speak very eloquently about this. But I'm happy to do whatever I can to get the committee to feel comfortable. Again, I really see this as a modernization and a restructuring that's good for Vermont. So I don't have all those counter arguments today, Senator, to the degree that they exist, but I'm happy to try to help the committee find other witnesses that may get you folks comfortable. Is that a fair answer to your question?
That's fair. I'd also ask Abby if she has any thoughts on that. I mean, it's hard. I mean, I kind of doubt that public assets is going to have
I do too.
on this kind of situation. That's not their focus. But I don't know what groups might have problems with this. And it's not that I don't fully respect the commissioner, but I think and there may not be counter arguments, but if, either Abby or the commissioner can think of things we might want to consider, that may be of relevance to the committee. I don't know.
I mean, from my chair, one thing I can say, right, is the governor's office has supported this, the main 4 proposals for 2 years now, and I have not had anybody come to my office and say, what the heck are you guys thinking? Right? What we see is our neighboring states doing the same reforms, similar reforms, experts saying it's not necessarily a question of if, it's a question of when. The only thing that I think was of concern last year was the price tag, right? And the price tag from the fiscal note last year was significant. And I don't know what the price tag will be this year. It should be significantly lower. But to the degree that it's not fully revenue neutral, I think that would open up a conversation of how to address that. But there are not a lot of policy arguments I'm aware of to counter this, I guess, is my answer off the cuff, Senator.
And I think this policy it may be an NCSL taxation committee. I'll trace it, we'll trace it down through the House committee and see who they saw and who they think would be helpful, just to explain why. I guess that's why make these changes seems to be the question. So we'll see if we can find that out. And Senator Pearson.
Yeah, thanks, Madam Chair. And I'm sure Graham will explain this to us, but Commissioner, do you have, why would we expect quite a different impact of this change this year compared to last year, that's unsettling to me. I'd love you to put me at ease.
I think I'll be able to do just that, Senator, and I apologize for not having addressed this in my testimony, but the significant difference between tax year 19 and tax year 20 is that we moved to market-based sourcing for services, right? So in the old regime, tax year 2019 and before, if you were selling services into Vermont, it was called cost of performance. So where did you produce that service? So let's say you're an architect, right? And you work in New York and you sold some plans to somebody in Vermont for a building. You did all your work in New York. So Vermont said that that income was New York's, not Vermont's. When you change to market-based sourcing, it's where is that sold, right? So now that is Vermont income. So you can think of financial services, telecommunications, other large service industries that are selling a lot of goods into Vermont previously had been sourcing that income elsewhere. But tax year 20 was the first year that we had market-based sourcing for those services. And I actually think that's really critical to remember as well as we talk about this, because many of the same policy arguments applied to that market-based sourcing discussion, right? Again, it was a what's the best reflection of how that service provider is generating income, right? Is it where they made the service or is it where they're selling the service? Right. Previously, I believe because the legislature passed this, that they were convinced the better reflection of income is who is buying that from you, right? Where are you selling it? And just like I'm talking about today, we had all of our neighbors having already enacted market-based sourcing before we had, which put Vermont companies again at a double disadvantage, right? Think of that same architect in Vermont selling to New York. They were having to count that as New York income and Vermont income. Right? It's very similar now when we do not have single sales factor and all of our neighbors do have single sales factor. So really, for a lot of states, moving to the single sales factor, moving to Joyce to Finnegan are natural next steps after doing the market-based sourcing. And we had very similar, I'm sure this committee remembers it well, but had very similar kinds of discussions about why this was important, why we should do it. This is kind of the natural extension of that. But that's why the numbers are so different. Is we're seeing a significant change in corporate revenues this year. Some of that has to do with change in the economy. Some of that has to do with pandemic influences, but some of it also has to do with the fact that we have market-based sourcing now.
Could I just follow up, Senator Hardy? Or thank you. And can you? One of the things that cropped up for me was a constituent who moved here and was continuing to work for the New York Times, and there was a debate for him, I know, whether the company was willing to have him employed here. And you know, I don't pretend to know it all, but apparently they had to establish some a tax structure in Vermont, right, just for one employee, and that's deeply at odds with, and I think we've talked about this, and it was hard to solve easily and fairly, but you know, we are trying to lure remote workers. That's a clear policy of the administration and the legislature. And are any of these changes, do they help those situations? Do they streamline our ability to get people to move here and keep their jobs in Boston, New York, elsewhere?
I'm loving these questions, Senator. Yes, that's the answer to that. We've heard of that challenge as well, right? And I don't have all of the answers on that, but the traditional problem was company doesn't have any employees in Vermont, employee moves into Vermont, and that might trigger corporate income tax nexus in Vermont, right? And that was a challenge for the companies because they don't want to set up withholding. They don't want to set up unemployment insurance. They don't want to start paying corporate income tax. And as we just talked about, some companies claim the protections of 86-272, right? Which means they might be selling a whole bunch of stuff into Vermont and not paying corporate income tax on it because of that federal law. The moment they have a full-time employee who's doing more than soliciting sales, that protection is out the window. So some of these companies might see significant changes because of that. This package of reforms, I can say doesn't help every situation, but helps some of them. And I can't think of any ways it hurts it. So let me talk about some of the ways that it helps. To the degree that a company is already paying corporate income taxes in Vermont, they could move 1 million jobs here and it won't impact their corporate income tax bill. Whereas today, it's going to increase their Vermont corporate income tax bill, right? So that's going to have one positive impact to having more ability for remote workers to come in without having a disincentive. What this also changes, because of the way we would be moving to Finnegan, thereby reducing the number of companies claiming Public Law 86272 protection, is you're going to have fewer companies that have a huge, I don't know what the right, but companies who are going to dislike their first employee moving into Vermont, right? Because you're going to have fewer companies claiming that protection and therefore losing that protection if they have one employee move in. And I think the long-term element of this is not fully going to be solved through tax, right? Because there are very few companies anymore that can fully claim they don't have nexus in Vermont, right? If you have a sale in Vermont, you have nexus. You might be able to claim the protections of 86272, but that's only for tangible personal property. So I think additional scenarios that this wouldn't necessarily help would be companies that like don't want to set up payroll withholding, don't want to set up unemployment insurance, which I'm not able to help. But the number of those kind of companies are going to get smaller and smaller if we enact these reforms.
Okay.
Thanks.
Other questions? Senator Hardy.
Commissioner, your example of the architect from New York City drawing plans, I think I might be confusing my taxes, which is totally possible, but they wouldn't, if we made this switch, they wouldn't have to pay corporate income tax.
Yeah.
What's
No,
the impact? But we don't, there's no impact on sales tax, right? Because we don't tax the service, the sales of that service. Is that
Yeah,
right?
that's right. I apologize if I use a confusing example, but yeah,
No,
it would change their corporate income tax bill, nothing to do with the sales tax.
Okay, it's just because we've had all these conversations about service and sales, so I was like, wait a second. But then, could you just give me or maybe whichever of you thinks you can do it better, a 2-sentence summary of the throwback rule, because it's this bill, like I think I understand something and then I don't understand it. And then I think I understand it again and my brain keeps going back and forth, but that's the one I'm not understanding right now. So the throwback rule, a 2-sentence summary again.
Do you want me to take a first stab, Abby, and you can correct what I get wrong?
Yes, sure.
So you're a Vermont company, you own a Vermont company, Senator Hardy, and you are selling things to other states. Because Vermont has a throwback rule, anything that you sell to the federal government or to a state where you don't have nexus or to a state where you claim the protections of 86272, right? So maybe you sell a bunch of stuff that you ship in through FedEx or UPS that goes to New York and you don't have any employees in New York. You're claiming the protections of 86272. And so New York can't apportion those sales to New York. So Vermont's law says all of those are now Vermont sales. And so the natural tension that exists between the rest of these reforms and the throwback rule is we're saying, look, if we all agree that a better reflection of income is where you're generating that income, in this case, New York, because that's where you sold the stuff, it's kind of arbitrary and punitive to then say these sales must come back to Vermont because of how you're taxed in New York. Does that make sense?
Yeah.
Okay,
but because we're going to single sales apportionment in this bill, right? We're just going to wouldn't that reduce the amount of taxable sales because we would then not be able to claim it as a Vermont sale?
Repealing the throwback rule would otherwise reduce the sales factor for those companies. Yes. But it's a very small piece. Like, I think the JFO estimate on this is $850,000 annually. Okay. And actually, I think that's high because once we apply Finnegan, the number of companies that can claim they don't have nexus selling into another state, or the number of companies that can claim 86272 elsewhere is very, very small.
Okay, so it's only that portion that that can claim 8672 or whatever. I don't
Yeah,
know.
like essentially the throwback rule says if you're not reporting it in that other state because of 86-272 or nexus, you report it to Vermont.
Got it. Okay.
Okay, so
think I
this is
get it.
kind of the reverse. If you pay sales tax in another state, you don't owe it in Vermont. If you don't pay sales tax in another state, you pay it to Vermont as a use tax. So this would be if you don't pay income on sales in another state or to the federal government, but if you don't pay tax on it anywhere else and you are a Vermont corporation, that income is subject to Vermont taxation. But
Yep.
if you pay it anywhere else, you don't pay it to us. You pay, yeah, everything gets taxed once. Is that?
I wish I could say in corporate income tax, everything gets taxed once, but
No, I know.
there's
Sales
a
tax
lot
is
of overlaps and gaps in corporate income tax among the
Right.
states. And it's just because of the mishmash of policy. I mean, this is a
Yeah.
great example of that, right? The fact that we are not, don't have the same policies that other states have means some companies are paying twice, some companies aren't paying at all. So yeah, it's never one for one, but that's the goal.
Okay. All right.
Madam Chair, can I speak to Senator Brock's question from earlier about the Tax Structure Commission report? I pulled it up.
Yes. Yeah,
So-
you did. Okay, good.
Senator Brock, it is in the final report, page 99. It's a very small section. And the recommendation essentially just says, we request that the Department of Taxes study the effect of adopting Finnegan. And I think part of the discussion at this point was the MTC has previously only endorsed the Joyce method, which is what we have today. And over the last few years, there was some buzz at the MTC that they were going to sort of pull back that endorsement and either be agnostic or possibly even endorse Finnegan. I believe they have gone to the place of being agnostic. So I think that was one of the driving factors behind studying this. But from my chair, I would say we have studied it, and in the context of all of these reforms, support that change.
Okay. Thank you. Committee, any further questions? If not, I think this would be a good time to take a 10-minute break because we're going to come back. It says ed financing flow chart, but this is really the weighting study flow chart, right? That we're going to look at 3. So take a 10-minute break and we will come back and go to the weighting study, another light thing.
Right.
Thank you,
Maybe-
Commissioner.
Maybe we
Thank
could have a
you,
short
Abby.
quiz when we come back.